Welcome back to Winning Isn't Easy. I'm often asked, can a disability insurance carrier or plan legally deny a claim if you're not treating with a specialist? People will ask me if it's a rightful denial, and I say, well, let's talk about legal as opposed to right, because what's right may not also be legal, and what is legal may not be right. Okay? Now, under virtually every disability insurance policy or plan, whether private or employer-sponsored or part of a group plan, there's a requirement that you receive appropriate medical care. And this typically means care from a qualified specialist relevant to your disabling condition. Failing to do so can be a legitimate reason for the carrier to deny the claim without even getting to the issue of whether you are disabled. Let me give you an example. Let's talk about the case of Gray versus United of Omaha. And it's a Ninth Circuit case. And in this case, Ms. Gray bought both short and long-term disability coverage. And she started to collect those benefits because of lumbar radiculopathy. Now, lumbar radiculopathy involves a bulging or a herniated disc pressing on a spinal nerve root, causing intense burning pain, numbness, and weakness, normally radiating down one leg. I've had lumbar radiculopathy, and it's excruciating. It's like having a burning match on your foot with the pain radiating from your foot up or the other way down. It's incredibly painful. Now, she submitted medical records from her treating physicians, but neither doctors were specialists in spinal or neurological disorders. And the medical records, unfortunately, lacked objective diagnostic studies, such as an MRI, CT scan, or an EMG. And these are the type of studies that are standard in evaluating lumbar radiculopathy. Carriers and judges expect to see this sort of stuff in a person's medical records. Now, it's also important that you're getting treatment by the appropriate specialist, but that the specialist is rendering an opinion that's supported by objective evidence, such as the lumbar MRI, CT scan, or the EMG and nerve conduction study test, so that they can render an opinion based on their physical exam findings of you, the diagnostic studies, and your subjective complaints, because doctors will evaluate those three things in rendering a diagnosis and formulating a treatment plan. In this case, her claim was further weakened because the opinions were provided by the doctors who weren't specialists and were based on her subjective complaints. Now, under the ERISA law, which governs most employer-sponsored disability plans, the court noted that the carrier assigned greater weight to their own reviewing physicians. And the court basically said, that's okay if the claimant is not being treated by a specialist and they fail to provide sufficient objective proof. And in this case, United of Omaha made multiple requests for further documentation, offering her several opportunities to submit imaging results or to consult with a specialist. And she failed to do so. The court, as a result, upheld that denial, saying, look, she didn't meet the burden of proof required under her policy. And I will tell you that this scenario isn't uncommon. Disability insurance companies are legally required to evaluate your claim fairly, but they also legally, by the terms of the policy or plan, have the right to insist on evidence that supports your diagnosis, that shows how your diagnosis and your symptoms impair your ability to do your own occupation or any occupation. And I hear all the time from carriers that having a diagnosis isn't enough. And they're right. You have to have documentation that connects your symptoms objectively to functional limitations that impact your ability to do your own or any occupation. So it's objective documentation correlated by objective physical findings that are consistent with the nature and severity of your condition. Those are the things that carriers are going to be looking for and things that we try to develop as we are representing our clients. So what are some of the key lessons learned here? One, always seek care from a specialist appropriate to your condition, a neurologist, an orthopedist, or a rheumatologist. And as part of that, I would say to you, you need to look at your policy or plan closely to see what the policy or plan says about the nature of the care. I recently had a case where the policy required specialty care, and my client was treating with a functional medicine doctor and a chiropractor. And by the terms of the policy or plan, those weren't the right kind of doctors. And so the carrier could legally ignore what the functional medicine doctor had to say and the chiropractor had to say. And that was because of the terms of the policy of the plan. Number two, undergo diagnostic studies such as MRI, CT scans, EMGs, neuropsychological testing to support your claim. That provides objective evidence of the basis of the diagnosis, but can also help address the intensity, duration, and frequency of your symptoms and how those symptoms impact your ability to do your own or any occupation. And number three, respond properly to requests for information and submit as much supporting evidence as possible that not only supports your claim, but addresses whatever it is the disability carrier or plan is asking. That was one of the big problems in this case. Mutual of Omaha invited her repeatedly to give them the documentation, and either she didn't take the clue or she just didn't want to go see the specialty doctors. Number four, consider getting second or third opinions, especially if your primary doctor doesn't specialize in your condition or refuses to complete the forms. Now, you can see if you're filing a disability claim, you've got the burden of proof. You have to be proactive. You need to get specialty care. You need to submit diagnostic evidence, and you need to follow through with every request that your insurance company or plan makes of you in regard to documentation. Clearly, as you can see here, the strength of your documentation makes or breaks your case. Got it? Let's take a break.